Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the official podcast of the Antitrust Law section of the American Bar Association. It seems like as long as there has been entertainment in print, on radios, and on screens, there have been ads. And the digital entertainment world is no different. For those of us in the Facebook generation, scrolling through ads to get to posts from our friends and colleagues has become a fact of life. But what if we could have paid to avoid having to look at ads? Subscription-based websites offer that option, and today we're going to be talking about an interesting approach that currently is being evaluated in the EU. My co-host today is Matthew Hall. Hello, Matthew.
Hi, Matt.
And who is our guest today?
Our guest today is Frithjof Michaelsen. Frithjof is Digital Policy Officer at UFC-Que Choisir, the French Federation of Consumer Associations, where he is currently seconded to the digital policy team at BEUC, the umbrella European consumer organization. His primary focus is advocating for consumer rights within the digital economy, with an emphasis on protecting consumers' personal data, ensuring fairness and safety in online services such as social media and marketplaces, and promoting consumers' access to digital infrastructure. Prior to joining UFC-Que Choisir in 2022, Frithjof spent 5 years as EU public policy consultant at Brussels-based firm VVA Economics and Policy, now EY. In this capacity, he conducted studies on consumer policy, the digital economy, and competition on behalf of the European Commission and the European Parliament. Hello, Frithjof.
Hello, and thanks for inviting me today.
Thank you very much for coming on the podcast. We are talking today about targeted ads and the EU rules on pay or OK. A lot of the discussion recently has been about Meta's situation. Can you give us some background to what has been happening in the EU in relation to Meta and pay or OK, please?
Yeah, so exactly what has triggered public attention to this question was a pop-up, or rather a paywall that users of Facebook and Instagram in the EU started seeing since last November, so a couple of months ago. But actually, to understand really the issue about this, we need to go way back, because this paywall, it introduced a pay or consent choice to consumers. So they were asked to either consent to Meta's data processing on Facebook and Instagram, or to subscribe to an annual monthly subscription of between 10 and 13 euros, depending on where they subscribe. But this didn't just come out of nowhere, because actually the whole story began with the GDPR. So the GDPR, the General Data Protection Regulation, it became applicable in the EU in 2018, in May 2018. And the GDPR, it requires companies to have a legal basis for their processing of consumers' personal data. And Meta, when the GDPR came into force, Meta chose the performance of the contract as the legal basis. Meaning, Meta said that in order to perform the contract that we have with you, the consumer who uses Facebook and Instagram, we need to process your data inter alia for behavioral advertising. Now, just a few weeks after that, after May 2018, a complaint was filed against exactly this, against Meta, claiming that it processes the consumer's data based on the performance of the contract. And then it took quite a long time until the end of 2022, so almost 4 years, for a first decision on the matter, which was taken by the EDPB, which is the European Data Protection Board, which reunites all the national data protection authorities, and the Irish Data Protection Commission, the DPC, which was the responsible data protection authority in that case. So at the end of 2022, they finally adopted the decision saying that indeed Meta cannot rely on the performance of the contract for processing consumers' data. So what Meta did in response then, a couple of months later, they changed their legal basis to legitimate interest, saying that it is in the company's legitimate interest to process consumers' data. So that was in the beginning of 2023. And already right after that, a couple of data protection authorities from some countries already said that this can't be right. And then shortly after that, in June 2023, there was a judgment from the Court of Justice of the EU, which was not directly linked to that case. It was on a different matter. But in this judgment, the court said that Meta can also not rely on legitimate interest for its data processing because it does have a legitimate interest, but this interest is overridden by the fundamental rights of the consumers.
If I could ask a question right there, was this the first time that a company like Meta had advanced these justifications for using consumer data in this sort of social media context, to your knowledge?
No, Meta is not the only company. Other companies are actually still doing this, other social media. They're still using performance of contract and legitimate interest for the data processing. There has been no procedure against them. And as I just explained, it has already taken a long time, just this one case against Meta, which is still not fully closed. It is also expected that this case will set the precedent then for other companies who are doing the same practice.
So it's fair to say a lot of companies will be watching this pretty closely.
Then what happened after this court decision, basically Meta only had one legal basis left, which they can use, because the GDPR, it lists the legal bases that are potentially valid. And a couple of those, they don't even apply to companies. And then performance of the contract, legitimate interest, they were all outruled by the authorities. So the only legal basis left for Meta to try is consent. And that's what they started then doing in November by showing consumers this pop-up asking them to make this choice. But it was not just a simple consent between, agreeing to share the data or not without any other consequences. But if consumers did not want to agree to the data processing, they had to subscribe to the monthly subscription. And this raises all kinds of concerns under consumer protection law, data protection law, under the Digital Markets Act, which is a new competition regulation in the EU. And the latest development in this long history of this case is that in January 2024, a couple of data protection authorities from Norway, from Hamburg in Germany, and from the Netherlands, they made a formal request to the EDPB, the Board of Data Protection Authorities, to issue an opinion on the pay or consent model. Because so far there's no consensus. There are DPAs who say it might be legal. There are others who say it's not legal. There's no definite decision on this. That's why they made this request, and we should expect a formal opinion from the EDPB on that around April, May 2024, maybe.
So, Frithjof, as you say, this is a long-running story. Currently, is proposing to use its pay or OK, i.e., you pay for no tracking ads, so no personal ads. You agree, i.e. the OK, to tracking and personal ads, which is, of course, the situation that it's been for forever. Or I guess you could alternatively delete and leave the platform. That's your third choice. This raises issues that you've just been discussing principally under the GDPR, but also under consumer law and the relatively new Digital Markets Act. We'll look at each of those latter two in a moment. I know that your organization has raised consumer law issues. So can you take us through what has been done on the consumer law side in terms of challenging Meta's proposed pay or OK model?
Yes, sure. So the main law in the EU that is relevant here is the Unfair Commercial Practices Directive, the UCPD. This directive, it bans unfair commercial practices, and unfair commercial practices are in particular misleading practices and omissions. That's in Article 6 and 7 of the UCPD, which are practices like giving false information to the consumer or deceiving the consumer. And the other type of unfair commercial practices are aggressive practices. That's Article 8 of the UCPD, which is basically impairing consumers' free choice by means of coercion or harassment. And we looked at that because what's interesting here with this subscription, which is part of the pay or consent, Meta adds a clear commercial element to this choice, which is originally a data protection mechanism, giving your consent or not. They added this commercial element, even if it's also there in a service where consumers do not pay, because there's still a contract, of course, but this payment makes the commercial dimension very evident. And also the unfair practices in this case were quite evident. So it was fairly straightforward approach to look at that first.
If I could ask, what is the nominal benefit to the consumer of the subscription? Would they be not seeing any ads, or would they continue to see ads and they're simply not targeted to them specifically?
It's actually a fairly confusing construct, this subscription that Meta proposes to the offers to the consumers. Because there is like a purely commercial offer in there, meaning that consumers who subscribe, they do not see ads anymore. So that's something that we see on many services, right? You can just subscribe to get rid of the ads that you see. And that is by itself not problematic at all. But what makes this confusing and also in many ways problematic is that Meta, they link this commercial offer to a legal obligation that they have under the GDPR, which is asking for consent. So consumers who subscribe, they're not just subscribing to this commercial offer, but they're also making a choice about their data processing. And what they get when they subscribe, it's actually not entirely obvious. And that's part of what makes this pay or consent paywall unfair, because it implies somehow that consumers who subscribe, first of all, that they won't see any ads, and secondly, that their privacy, the privacy of their personal data, will be respected. But actually, neither of that is totally the case, because first of all, they will not see ads anymore that are shown directly on their Instagram or Facebook feed. But what consumers will still see are what is called sponsored content. So posts of influencers who promote products. This is not an ad that is shown in the feed, but it's like an integrated ad integrated into the content. And this consumers will continue seeing. But these are not ads by Meta's definition. But I think from a common understanding of advertisement, that clearly counts as ads as well. And then the second point on the data processing, that will not entirely stop either. It will stop only for the purpose of showing personalized ads, but Meta will continue collecting and processing data for other purposes, for example, for personalizing the content or for offering services to other companies and so on. And the fact that this is not entirely clear, it's very hard for the consumer to understand what they actually get when they pay. That is already a misleading practice under the UCPD. On top of that, there are a couple of other misleading practices. For example, there's the use of dark patterns, which is something that we always see in these contexts about data processing and so on. Very classical things like button colors. So on this paywall that consumer sees, there is one button to accept the data processing, to give consent, which is blue, and then the other one to refuse the consent, to subscribe, is white. So that's a very traditional dark pattern that we know very well in the EU from consent banners on third-party cookies. There are also dark patterns in the framing and in the wording. For example, Meta presents the consent option. They present it as use for free, whereas there have been already judgments from the Court of from the Court of Justice of the EU saying that this kind of service where the consumer, they don't pay with money, but they have to provide their personal data in return for the service. These services are not free, and companies are not allowed to label these services as free. So there are already court decisions saying that Meta is not allowed to do that. And then on top of that, there are aggressive practices, in particular the fact that this paywall, it blocks complete access to the service, to Facebook or Instagram, meaning that the consumer who wants to access their messages or get in touch with their contacts, they can't do this. They go on the platform, they see this pop up, and they're forced to make a choice immediately, which it creates a sense of urgency, pressure, and which is particularly problematic in the case of Meta, because Facebook and Instagram, these are dominant platforms. They are not really alternatives on the social media market. So consumers can also not just say, okay, I don't care, I go somewhere else. They're really forced to make a decision on the spot, which is in itself an aggressive practice under the UCPD.
Related to that, I think BEUC is also saying that the mere fact of having to make that choice is not a real choice, because if the alternative is to quit, then you lose all your contacts and interactions built up over the years. So that would be another alleged infringement of consumer law.
Exactly. And consumers cannot go just somewhere else, because Facebook and Instagram, both of them have over 250 million users in the EU, which is way more than even the biggest competitors, which would be Twitter or TikTok, which only have around 100 million, which means that the consumer cannot just go to one of those because many of their contacts will not be there. And on top of that, these are also not particularly comparable, because TikTok, for example, does not have at all the same target audience, especially for older people. Those are not present as much on TikTok as on Facebook or Instagram. So those consumers will not find their contacts, and also not the same kind of content that they look for if they switch from Facebook to TikTok. So there are really not any realistic alternatives for consumers.
So I guess at least for that issue, it may be arguable that other platforms shouldn't be treated in the same way. Let's look in more detail at the data protection side, please, Frithjof. You mentioned in your introduction that there are 3 bases that might be relevant for Meta and similar platforms to process personal data, those being consent, which is where Meta started, and then contract, which it moved to, or contractual necessity for performance of a contract, then legitimate interests, which it moved to, but then it moved away from following the ECJ judgment in the Meta Bundeskartellamt case, and now it's back to consent. So consent under the GDPR, as you mentioned in response to Matt's question, this is used in other EU digital services. Some newspapers have implemented pay or OK as a apparently valid consent route. But what is consent under the GDPR first, and what are the requirements for consent to be validly given?
So consent means that the consumer, they have to explicitly agree. Well, they have to be asked, first of all, by the data processor, and then they have to explicitly agree to the data processing that the company wants to do before the company can start doing this. And the GDPR sets some requirements for what constitutes a valid consent. This is set down in Article 411 and Article 7 of the GDPR. And those say that consent needs to be freely given, specific, informed, and unambiguous. And it's especially the freely given requirement that raises questions here with regard to the pay or consent model. Because the key question here is, if you are asked to make a choice between 2 options, and one option doesn't cost any money, and the other option requires you to pay to subscribe, how freely can you choose between these maybe not very equal options? And there's some interesting statistical data showing that between 80 and 90% of consumers do not want to be tracked. They don't want to agree to this kind of data processing, especially for behavioral advertising that Meta does. So it's the vast majority of consumers do not want that. And you can see this when they have a choice between consenting or refusing to consent, where both options do not cost anything, then 80 to 90% of consumers choose the refuse option. But if a payment is introduced, and it doesn't even need to be as high as the payment that Meta asks, which is 10 to 13 euros, even a lower payment. If a payment is introduced, then 98 to 99% of consumers choose the option that does not cost any money, meaning they consent to the processing of the data. So it shows that almost all of consumers change their choice and choose the option that implies a data processing that they actually do not want. So you can clearly see that the payment has a big impact on the choice that consumers make. And you spoke of other operators earlier, Matthew. That's a really important element here because the economic consequences can be quite important. We've seen this practice before Meta in particular on publisher sites, but it was still rather limited. Now Meta is the first big company who offers quite essential services on top of that, because social media nowadays, they have basically replaced what television, newspapers, and telephone used to be in the 20th century. So for many consumers, it's really essential. And now this operator puts in place this pay-consent model, and if they manage to get away with that, then it's very likely that other operators, other providers will follow suit. And this means that for the average consumer who has 30, 40 apps on their phone, if they have to pay 5 to 10 euro subscription, even just for a third of that, that will sum up really quickly. And maybe will lead to a situation where data privacy becomes a question of income and wealth, a luxury. There's no consensus so far among data protection authorities. There are some that have said in the past that pay-OK might be okay for publishers in particular, but under certain conditions. There are other DPAs who have said in the past that they think it's not legal in general, this model. That's why there is now this request for an opinion from the European Data Protection Board. The Court of Justice has mentioned this in their Bundeskartellamt decision. What they said is precisely that those users who refuse data processing, and I quote, are to be offered, if necessary for an appropriate fee, an equivalent alternative not accompanied by such data processing operations. So that's interesting. Meta says that the court endorsed their pay-consent model. I think that is definitely an exaggeration because, first of all, this is just an obiter dictum of the court, which they said in passing in a judgment that was about something else. Secondly, the court said in this half sentence that the fee must be appropriate. It's a tricky question because how do you assess this? There is zero indication in the GDPR. The GDPR simply did not foresee the case that a provider might start asking for a payment. The data protection authorities are not really equipped to do this kind of economic assessment. It will be a big challenge for them because they would really basically become pricing regulators. But more importantly, the court also said, on top of the appropriateness, that the fee must also be necessary. The court didn't really give any indication of what would make the fee necessary, but it's a really important question to answer, especially knowing that there are alternatives to the behavioral advertising. There are contextual advertising, there are freemium business models, which are much less. So it will be up to Meta to show that the fee is really necessary for their operation. But what is clear is that they need to have a business model that complies with the law. And it's for them to choose the business model that is legal.
Yeah, and the issue for them, as you say, as we've been discussing, is that at the moment, the only model that could, it seems, work under the GDPR is the consent model. And then you've been explaining why that may raise issues, and particularly given the alleged lack of the decision being freely given. I think it's important to flag up, and you mentioned it, those quotes from the Meta v. BKA judgment, which is, as you say, what Meta is often refers to. And I think it's also useful to mention the NOYB Austrian consumer organization has made a complaint on this basis of the consent not being freely given under the pay-or-OK model. On a further aspect, which the NOYB, which is led by Max Schrems, who made the original complaint back in 2018 about Meta's use of data, which was the decision didn't come out, as said, until the end of 2022. But NYB has made another complaint about another aspect of the model. So can you take us through what that aspect is as well?
Yes, indeed. So they have made the first complaint that they made was a lot about this economic argument that I already mentioned, meaning that putting in place payment will become a huge burden, financial burden on consumer and thereby impact their free choice. The second complaint that they filed is about a specific part in the GDPR that says that it must be as easy to withdraw consent as it is giving it. And that's a very interesting angle indeed, because to give the consent in this particular case, consumers, they go on the service, they see the paywall, and in order to give their consent, all they need to do is click on what Meta says, use for free, and then they come to a second page where they just confirm their choice, and that's it. So the consent is given as easily as that. If consumers want to withdraw their consent now, there are two things that make it more difficult than giving the consent. First of all, they need to find the option on the interface to do that, which needs to first, they need to navigate through the settings on Facebook or Instagram, which, first of all, if you know where it is, it already takes a couple of clicks, but it's not that evident. So most consumers will have to click even more just to find that. So that's the first thing that makes it more complicated. And then the second thing is the payment, because you don't just click on I withdraw my consent, but what consumers have to do, they have to subscribe, which means that they have to enter their payment details. They come to a different window. They have to get their credit card information, put it in, maybe confirm it with their banking app. So there are many more steps which also make this withdrawal process much more complicated than the consenting process.
And I think the challenge you face there, I will say for myself, there might be a reluctance on the part of consumers, even those who are inclined to pay the fee. They may not want to pay it through the app. They may want to pay separately. So there's an added dimension there as well, I would imagine, about having an alternative method of providing that information if you don't want that vendor necessarily to have your payment information saved somewhere in its systems.
Sounds right, Matt. Maybe NOYB should adopt that as part of their complaint as well. Frithjof, so that's the second aspect of the NOYB complaint, and that's the data protection side of things. We mentioned, or you mentioned at the beginning, that the EU's famous Digital Markets Act and compliance with that. So just to explain a bit, the Digital Markets Act is now coming into force, or has been in stages. Meta, along with other companies, has been designated as a gatekeeper under the DMA, and certain of its services have been designated as core platform services because of their size. So that includes Facebook, Instagram, Facebook Marketplace, Messenger, WhatsApp, and importantly, Meta Ads. Meta seems to be saying that PayROK also makes it compliant with certain obligations under the DMA as well. So can you take us through, please, what the issue is here and how PayROK might be interpreted against that background?
Yes, so the DMA puts in place lots of interesting obligations for these gatekeepers. But the one that is most interesting here in the context of the PayROK is Article 5.2 of the DMA. Because that article, it creates obligations in the context of data processing. So for certain types of data processing that the gatekeeper wants to do, they need to ask consumers for their consent first. And that is data processing when the gatekeeper wants to use personal data that they obtain from a third party in order to show personalized advertising. So that's the first case. And the second case is if the gatekeeper wants to combine or cross-use consumers' personal data across several of its own services. For example, if Meta wants to use personal data that they collected on Facebook, also on Instagram, or to combine data from a consumer's Facebook and Instagram account to create a combined advertising profile, for example. Or use this data then on Meta Ads, which is another core platform service. So it does not even stay within Facebook and Instagram, but it really, most of Meta's consumer services, but also business services are concerned by this. And as I said, in order to do this, Meta needs to ask consumers for their consent. And first of all, so the requirements for this consent are interesting. First of all, the DMA just refers to the GDPR, saying that in order for this consent to be valid, it needs to fulfill the same as under the GDPR. And we already discussed this. It's questionable whether the consent can still be freely given if there's a payment. Soon we will have an answer to this, but this question is there. And obviously, if that does not comply with the GDPR requirements, it also automatically does not comply with the DMA. But on top of that, the DMA introduces additional requirements on the consent. So what the DMA says is that if the consumer wants to refuse this data processing, this cross-use and combination of data, etc., the gatekeeper needs to offer a less personalized version of the service. And what's important is that this service must be equivalent. And the gatekeeper cannot degrade the quality or the conditions of the service. What does it mean in practice? So in this case, Meta needs to offer for the consumers who refuse a service without personalized ads. They probably do this to the consumers who subscribe. And so there is a less personalized version, but the question is to what extent this version of Facebook and Instagram is actually equivalent. It is probably equivalent in terms of the contents that the consumer can access, because they have their news feed, they have their messaging, their contacts, etc. But what's interesting is that this aspect of degrading the quality of the conditions, and there the question must be raised whether a payment is not a degradation of the conditions. Because for a normal consumer, the financial aspects are clearly part of the conditions of contract. There are no real explanations or guidelines on what constitutes degradation of the conditions, because this text is completely new. It's to be seen how the European Commission, who is the one that can act and who can enforce the DMA, how the European Commission will interpret this aspect and how they will react to Meta's pay or consent model.
So those degradation provisions, I think, are often referred to as the anti-circumvention provisions in the DMA, and that's why there's often references to whether or not the pay or OK infringes the anti-circumvention. And I think it's also interesting to point out when the European Commission was looking at designating core platform services, Meta was arguing that all of its services form part of a single ad-supported network, including all of those services. Presumably the reason there, or one of the reasons, was so that these issues about cross-transfer of data would not then become relevant. Is that right, do you think?
Exactly, because if all of Meta services were just one thing, then there would naturally be no cross-use or combination of data. But Meta has not been very consistent, because clearly all these services are, the way they are presented to consumers, but also to business clients of Meta, they are all completely separate. And for example, Meta has also made the case that Messenger is not a separate service, but it is part of Facebook, which is partly is because it is integrated into Facebook. But at the same time, Meta also offers a separate Messenger app, a separate Messenger website. The consumer can use Messenger without using all the rest of Facebook. So Meta's practice and Meta's defense in the context of this DMA designation, it doesn't really go very well together.
Yeah, let's finish off our substantive discussion with some wider implications. And Matt raised this earlier, but I think these questions are probably related to each other. What do you see as the implications of all of this for the wider ad tech ecosystem? And maybe on the other side of that coin, how would the BEUC actually like to see the ecosystem here operate? If Meta can't and others can't charge, that's obviously their business model, to pay to have ads or to get a subscription. You mentioned an alternative being contextual advertising. You mentioned freemium business models.
Yeah, I already mentioned before that if data protection authorities find that there's no issue with pay or consent in general, and in the way that Meta implements this will potentially have very wide implications, because it's very likely that many other operators will follow through and also implement this kind of model, even if at the moment we can't really predict who and when and how, but it's still a very likely case to happen. we talk about other providers who already use pay or consent, notably publishers. So for them, I think there are mainly two possible implications. If the data protection authorities find that pay or consent is generally illegal, then obviously these publishers will not be able to do this anymore. But it might also be the case that data protection authorities say that it's not generally illegal, but it is not possible for Meta in this particular case. In that case, publishers could continue. And then it would be up to case-by-case decisions for each publisher to see if they do it in the right way or not. And there are arguments to say that Meta and publishers are not the same type of company. They do not do the same type of processing. So it could be possible that the decisions are not the same. And then if the data protection authorities find that the way Meta does it is not legal, then that will have very interesting implications for Meta, first of all, because they need to probably change their data processing, because consent is the last legal basis that they have. If they cannot ask for payment in return, then the majority of consumers will, as we know from past statistics, they will not give their consent, and Meta will have to find probably or make changes to their business model. But it also has wider implications because Meta has a very particular position in the ad tech industry, because they have a dominant position in the ad tech industry, because they play a role on all the steps of the value chain, from being a publisher to being an advertiser to being a provider of ad tech technology and services. And if there's only one other company which has a similar position, which is Google, and if Meta is not allowed to do this kind of processing, then obviously it would also be the question would have to be raised: what is with Google's processing, and if they can continue to do this, and if these two big giants of the ad tech industry will be forced to make changes to their kind of data processing for behavioral advertising, then this would, of course, have very big implications for the whole ad tech system and the whole, business model of behavioral advertising as such. With regard to what BEUC would like to see, there are several layers linked to these three areas of law that we discussed. For the consumer law, it's quite obvious. Basically, we would like to see Meta stop being unfair to consumers. That means stop using dark patterns, trying to manipulate the consumer's choice, stop using vague language, and stop pressuring consumers with aggressive practices into making a hasty choice. And these are, so now we're talking about Meta, but these are actually common practices that we see from all kinds of providers all over the internet, basically. But stopping these unfair commercial practices, that would be great, of course, but it doesn't really attack the question at its core, which is the data processing. And data processing from all kinds of companies, but especially, of course, within the context of ad tech and behavioral advertising, which is problematic. And in a way, the pay or consent model that Meta introduced, it could even be seen as a sort of smokescreen to divert the attention away from this data processing, because now it has created these discussions about whether Meta has the right to do this, whether we should accept pay or consent in general, and what would be the appropriate price, etc. But even if consumers only pay, let's say, €1 instead of 10 for Meta's subscription, that would still not change the data processing that is going on behind. And what is important to note here also that the GDPR, it does not only talk about lawfulness and having a lawful, valid legal basis, in this case consent, but there are other fundamental principles in the GDPR, which are, for example, the principle of fairness, the principle of purpose limitation, the principle of data minimization. And there are very strong indications that this kind of massive data processing that is done by Meta, that it also violates all these other principles of the GDPR. And it's very questionable that Meta can comply with these. So it's important also from a regulatory point of view that data protection authorities, they don't just look into this question of pay consent, but they really see the big picture and look at the data processing that's going on behind the scenes.
Thank you, Frithjof, for that very interesting discussion about all of the consumer ramifications of these issues. As you may know, we like to end our podcast on a lighter note, and so I'm going to ask you a couple of questions. First of all, we'd like to ask guests, tell us something about yourself that's interesting that your professional colleagues might not know about you.
Perhaps I can tell one funny story, which is that in my whole life, I only owned a car once, which was a very old Polish Fiat, a very small Polish Fiat, which used to be the standard, basically the only car model in communist Poland. Not obviously, you cannot see me, the listeners, but I'm not as old as having lived in communist Poland. So I bought this car in the 2010s when most of these cars were not on the market anymore. It was actually very cheap. It didn't run very well, and it broke down only after around 2,000 kilometers. When going around with this car in Poland, but also outside in other countries of Europe, whenever there was a Polish truck passing this car, they were honking because they were so happy to see this car that they knew from their past. And I would have liked to keep this car longer, but it didn't really make it that far. And since then, I never had another car. I only go around by bike. Let's see if it stays this way for the rest of my life. Maybe I will get another car in the future, but for now, I didn't really need one.
That's fascinating. Thanks for that. We close out every episode with a segment that we like to call the Curious Hat.
And now it's time for the Curious Hat.
So your Curious Hat question for today is, if you were given 50,000 euros on the condition that you had to spend it all in 1 hour, what would you buy?
To do a really crazy thing, I might buy an airplane. It doesn't sound like a lot, 50,000, but it is actually possible because I looked this up before, not because I really wanted to buy one, but just as a funny idea. And I was surprised that you can buy used, not new airplanes, of course, but a used airplane for, it starts at around 50,000 euros. I don't have a pilot license, so it wouldn't be very useful, at least not in the beginning. But that was always a funny idea that I had, that it would be nice to have a small private airplane that you could go around with fast and without having to go through all the security hassle at public airports.
And hopefully it would run better than the one automobile that you previously owned.
Indeed, because it would be a big security risk if it were in the same bad shape as this old Polish car.
Frithjof, thanks again so much for joining us for today's episode. Matthew, thanks so much for guiding us through this substantive discussion. And thank you, our listeners, for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.